So another bump stock lawsuit is now seeking Supreme Court review to overturn the ATF's current overreach. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has absolutely amazing coffee and they are huge Second Amendment supporters. If you buy one of their dedicated roasts for FPC or GOA, some of those proceeds go directly to those organizations so they can file lawsuits like this one here. So again, check out Blackout Coffee, and if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I mentioned in the intro, we just received important news that another case is now seeking Supreme Court review. This case we're going to be discussing is called Guidez v. ATF, and you might recall that recently we talked about a different case which dealt with bump stocks and the ATF's new rule, which is Hardin v. ATF. Hardin is a case decided by a 3-judge panel in the 6th Circuit. In that case, the court ruled that the ATF's final rule on bump stocks is in fact invalid. That decision struck another major blow to the ATF's current overreach in creating new rules whenever they feel like it to ban specific types of items and firearms. This decision was important because it created a situation where multiple courts of appeals have now ruled that the ATF's rule on bump stocks is in fact an overreach and is in fact unconstitutional, and that these items like bump stocks are not machine guns under the NFA and GCA. You also recently had the 5th Circuit en banc panel rule in a case called Cargill, which also found that the ATF's bump stock rule is in fact invalid. Here you have the Guidez case, which has been around for a while. In fact, I covered this case about 3 years ago on the channel. It's one of the first videos that I ever made, is when we covered this case in the original petition to the Supreme Court in the Guidez case, and the Supreme Court denying that decision or denying review in that case at that time. And now this case has come full circle. It's once again up before the Supreme Court seeking Supreme Court review, and now it has an even better chance because you have 2 other cases that are also doing the same thing. Currently, you have 2 bump stock cases that originate out of Circuit Court appeals striking down that rule on bump stocks, and now you have a lower court which has upheld the rule in the Guidez case. So now you have a very interesting circuit split that is presented before the Supreme Court and is seeking Supreme Court review. This type of landscape now sets the perfect type of constitutional question and the type of difference in opinions that may set the groundwork for the Supreme Court actually want to review this case, and this could be one of the next major two-way case decisions, which would be a review of the ATF's rule on bump stocks. One of the important aspects of all of these lawsuits is whether Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different rule called the rule of lenity should in fact be used instead. So in the Hardin case, the 6th Circuit came to a different conclusion than what we saw a previous Circuit Court of Appeals do in the Cargill case. In the Cargill case, the 5th Circuit en banc panel found that the text of the NFA and GCA was in fact very clear, and they found that the plain text of the NFA and GCA expressly does not include items like bump stocks, and bump stocks can never be considered to be machine guns. Then later in the same opinion, they went on to say that, well, even if the term was ambiguous in some way, you would use the rule of lenity, not Chevron deference. In the 6th Circuit Hardin case, the court started from the position that the term and the statute is in fact ambiguous, and therefore they moved on to see what doctrine should then be applied to that ambiguity, and ultimately they said you would never use Chevron deference, but instead you would use the rule of lenity. Now, in contrast to those 2 decisions, which ultimately led to the same conclusion that bump stocks are not machine guns, the court in the Guidez case found that bump stocks mechanically were in fact machine guns under the text of the NFA and GCA. In the Guidez Supreme Court petition, the plaintiffs state that below the DC Circuit Court of Appeals upheld the ATF's rule and its criminalization of non-mechanical bump stocks. In doing so, the DC Circuit Court joined the 10th Circuit in finding the rule lawful. But while these courts reached the same destination, they took different paths. The DC Circuit became the first circuit to conclusively hold that a bump stock is a machine gun under the best interpretation of the statute. A deeply fragmented 10th Circuit held that the rule could only be upheld under the deference it believed was required by Chevron. The plaintiffs then go on to say in their petition that those 2 positions taken by the 10th Circuit and the DC Circuit Court of Appeals is drastically different from what the 5th Circuit and the 6th Circuit said in their decisions. They go on to state in their petition that as of now, at least 30 opinions authored or joined by 57 different federal judges, totaling over 400 reported pages, have addressed whether non-mechanical bump stocks are properly understood as machine guns as defined in section 5845 subsection B. These opinions are divided both on the ultimate merits and the appropriate interpretative method to decide them. That the courts of appeals are so divided on an issue of federal law is itself sufficient for the court's review. That the issue involves criminal consequences for otherwise ordinary law-abiding citizens makes the need for review particularly compelling. That the issue goes to the heart of federal agency power, touching both what is a crime and who can deem it so, makes this court's review absolutely necessary. The plaintiffs in the Guides case state that petitioners respectfully submit that now is the time for this court to address the long percolating issues raised by this case, and accordingly, this court should grant the petition. So what this does is it sets up a situation where you have two cases seeking Supreme Court review that are on petitions to the Supreme Court that have come from and originate from two circuit courts of appeals, the 5th Circuit and the 6th Circuit, which have concluded that the ATF's bump stock rule is in fact unconstitutional. Now you have the Guides case, which has once again made its way up to the Supreme Court, which is also seeking Supreme Court review, but it comes from a decision down below where the DC Circuit Court of Appeals has actually upheld the ATF's rule and said that the ATF can engage in this type of regulation because under their interpretation, bump stocks are in fact machine guns. The Supreme Court typically grants review in cases that have national significance and when a review of them is necessary to essentially harmonize any conflicting lower court decisions on the very same topic. Here with the ATF's bump stock rule, both of those elements, those key elements, are in fact present. The ATF's rule-making process on bump stocks and other items like pistol braces does have national significance, and of course there is also going to be significant Second Amendment implications, which again is very important. But then you have the Guides case joining these two other cases up before the Supreme Court, which shows a very serious circuit court split on this same topic. And interestingly, like I mentioned before, about 2, maybe 3 years ago, I covered the Guides case and the original petition for a writ of certiorari up to the Supreme Court, and the Supreme Court denying it. And in that denial, there was actually, I believe, some statements from Justice Gorsuch where he stated that do not take his or their, I guess, denial at that time of the Guides case as any indication that they were not interested in this topic, that they would not address that topic. It was simply at that time there was some issues procedurally because Guides originally made its way up to Supreme Court on an interlocutory posture where they were, I guess, essentially disputing whether or not an injunction should have been issued by the DC Circuit Court of Appeals, and it wasn't an ultimate resolution on the merits of the case like it is now. But you did have some language from Justice Gorsuch where he said just now was not the time at that time, and now fast forward 2-3 years later, and you have multiple Circuit Court of Appeals have struck this down, and now the Guides case is back up before the Supreme Court on the ultimate merits of the case. I still think the Cargill case out of all these cases is the best option. I think it has the best chances of being granted Supreme Court review. I think maybe these other cases, Hardin and Guides, will then be kind of consolidated under what happens in Cargill, and then whatever happens in Cargill will then be applied to Hardin and Guides. But if we get any more information on this, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.